Hi everyone, I'm Mrs. Kritika Singh, the Director of Efficacious Judicial Law Academy. We have started with the series of Indian Evidence Act. The introduction to Indian Evidence Act I have shared in my previous video, the description to which I will be sharing in the description box. And in today's video, I will be covering fact, relevant fact, and fact and issue under Indian Evidence Act. So the term fact has been defined under Section 3 of your Indian Evidence Act. If we look into our BEAR Act, Section 3 of the Indian Evidence Act defines the term fact as fact means and includes anything, state of things, relation of things capable of being perceived by the senses. Capable of being perceived by the senses. ऐसी चीज जो आप देख सकते हो, जिसको आप फील कर सकते हो, जिसको आप सुन सकते हो, जिनको हम कहेंगे physical facts. We can call them as physical facts. आप यहाँ लिख सकते हो, if you have your BEAR Act, take a lot of notes while you're watching this video. So these are the physical facts. And subsection 2 states any material condition of which any person is conscious. Mental condition. Mental condition means something which you are aware of consciously. Awareness means that you have knowledge. So as per section 3, we understand that physical fact and mental fact is a fact as per section 3. Mental fact, it is very important that the fact is within knowledge. Fact is within the knowledge. That is awareness and consciousness of the person. So the fact which is within the knowledge and awareness and the person is conscious. It's very important that the person has to be conscious. अगर आपके subconscious mind में कोई fact है, then that is not a mental fact. That is not a fact as per Indian evidence. अगर subconsciously आप कुछ सोच रहे हो, कुछ apprehend कर रहे हो, then it is not a fact. And a physical fact would be anything that you can perceive by your senses. A fact that I heard the children crying is again a physical fact. So anything that you can hear, anything that you can smell, anything that you can feel are physical facts. And in case of mental fact, you have to remember कि वो जो fact है वो आपके knowledge में होना चाहिए, conscious mind में होना चाहिए. Subconscious mind में अगर कोई fact है तो वो mental fact नहीं है. So basically the facts which are physical or mental facts, इन facts में से हम main facts निकालते हैं. हम main facts जो हैं वो निकालते हैं. Main facts मतलब primary facts. Or we also call them as factum probanda or the factination. So basically, out of the whole facts, we have to now take out the primary facts, the factum probanda, the factum probanda, the fact in issue. इसको हम कहते हैं fact in issue. Let's take an example to understand. A enters into a contract with B. All right, and B violates the contract. He violates the contract. इनका आपस में contract हुआ. Now, what are the main facts that A needs to establish to assert his cause of action? And what are the main facts that B needs to establish to defend the cause of action of A? So the main fact would be that there was a contract. अगर कॉन्ट्रैक्ट ही नहीं है तो वायलेशन किस चीज का होगा और आप कोर्ट से रेमेडी क्या मांगेंगे, राइट? सो द फर्स्ट फैक्ट दैट यू हैव टू प्रूव इन द कोर्ट इज दैट देयर वाज अ कॉन्ट्रैक्ट. ए असर्ट करेगा, बी उसको डिनाई करेगा कि कॉन्ट्रैक्ट था या कॉन्ट्रैक्ट नहीं था. सेकंड, देयर वाज अ ब्रीच. दैट्स द सेकंड मेन फैक्ट कि कॉन्ट्रैक्ट था और बी ने उसका ब्रीच किया है, वायलेट किया है उस कॉन्ट्रैक्ट को. एंड थर्डली, द क्वांटम ऑफ लॉस, द क्वांटम ऑफ लॉस दैट ए हैज सफर्ड ड्यू टू बी's breach. Now these are the main facts, and if you reflect, you will understand that these main facts we derive from substantive law. Substantive law. Substantive law हमें बताएगा, या इस केस में substantive law कौन सा है? इस केस में हमारे पास substantive law है the Indian Contract Act. Indian Contract Act. So Indian Contract Act will tell us that whether there was a contract, what are the essentials of a contract? Whether there was a breach, contract breach कब होता है, और अगर breach हुआ है तो उसके losses हम कैसे calculate करते हैं. So we get the main facts or the fact and issues from a substantive law. From a इनको हम कहते हैं fact and issue. Now, if we look into the definition of fact and issue as per Section 3 of the Indian Evidence Act, we are going to understand this definition. We will mark the keywords and then I will relate this definition with the example that I've just now given. The expression fact and issue means and includes any fact. Now, what is a fact? A physical fact or a mental fact from which either by itself or in connection, these are the key words of the section, connection with other facts, the existence, non-existence, nature and extent of any right, liability or disability, asserted or denied in any suit or proceeding necessary for this. So basically, if we see what this definition is saying, a fact and issue means and includes a fact from which either by itself or in connection with other facts, existence, non-existence, nature or extent of any right, liability or disability, asserted or denied in any suit or proceeding necessary follows. Now let's just break this down and write this definition. So as per Section 3, Indian Evidence Act, the term fact and issue is defined as any fact which either by itself, or in connection with other facts. So first half of the definition says that fact and issue is any fact either by itself or in connection with other facts. Let's say, for example, any fact, A killed B. Now this fact that A killed B either by itself or in connection with other facts does what? Existence, non-existence, nature or extent of any rights, liability, or disability. Any right, liability, or disability is asserted or denied in any suit or proceedings. So what I've done is I've just simply made a skeleton chart of the definition that was given in your section 3. And as per the definition which was given under section 3 of the term fact and issue, it states that any fact, either by itself or in connection with other facts, existence, non-existence, nature or extent of any right, liability, disability is asserted or denied in any suit or proceeding. So now this fact that A killed B, either by itself or in connection with other facts, does what? Proves or establishes the right or the liability or the disability, which is being asserted by A and it is being denied by Mr. B. So A killed B is a fact. Now this fact, either by itself or in connection with other facts, creates a right in favor of B. That is, that he has a right to life. And in case he's been killed, then the person who killed him will have to face the liability or the disability. And for that, he will have to assert that yes, A killed B. He will assert and prove it by proving the ingredients given under section 299 or section 300 of Indian Penal Code. And in case A wants to deny his liability, A क्या करेगा? वो डिनाई करेगा अपनी लाइबिलिटी को. जो अक्यूज्ड है वो अपनी लाइबिलिटी को डिनाई करेगा. और वो कैसे डिनाई करेगा अपनी लाइबिलिटी को? He will prove a fact. What fact? Let's say he proves that A killed B not because he had intention, but because he wanted to defend himself. He killed B in private defense. So now a fact. What fact? A killed B in private defense. Now this fact, either by itself or in connection with other facts, creates any kind of right in favor of A or liability, disability, which is being denied or asserted by A in any suit or proceeding. So I've made it very simple for you to understand what is a fact and issue. Fact and issue is the main fact. इसको हम कहते हैं प्राइमरी फैक्ट. और वो फैक्ट्स जो एक पार्टी असर्ट कर रही है और दूसरी पार्टी डिनाई कर रही है. एक पार्टी असर्ट कर रही है, दूसरी पार्टी डिनाई कर रही है. जो पार्टी असर्ट कर रही है वो अपना राइट एस्टैब्लिश करना चाहती है और जो पार्टी डिनाई कर रही है वो अपना लाइबिलिटी को डिनाई करना चाहती है. उन फैक्ट्स को हम फैक्ट एंड इश्यू कहते हैं. लाइक आई गेव यू दिस एग्जांपल आल्सो दैट यू नो दैट देयर वाज अ कॉन्ट्रैक्ट, देयर वाज अ ब्रीच, व्हाट वाज द क्वांटम ऑफ लॉस. ये सारी चीजें ए प्रूव करेगा. ये इसके फैक्ट्स हैं, ये इसके फैक्ट एंड इश्यू है. नाउ व्हाट विल बी प्रूव? बी विल प्रूव दैट देयर वाज अ कॉन्ट्रैक्ट but it got frustrated. And if he is able to prove that there was a contract but it got frustrated, in that case he will be able to deny his liability. वो अपनी liability को क्या कर लेगा? He will be able to deny his liability. So all in all, what is a fact and issue? It is the actus reus plus the mens rea. और ये जो मेंस रिया है हम इसमें डिफेंस भी ले सकते हैं. राइट? We can take a lot of example from civil law and criminal law to understand fact and issue. Like also I gave you an example. Let's say A killed B. This is a fact in issue. This is the main fact. This is the primary fact. अगर आपको मर्डर प्रूव करना है तो आपको प्रूव करना पड़ेगा दैट ए किल्ड बी. आपको प्रूव करना पड़ेगा दैट ए हैड इंटेंशन टू किल बी. You will have to prove that A killed B in a manner which falls under rarest of rare case. So ये सब क्या है? ये सब है आपके प्राइमरी फैक्ट्स. ये सब है हमारे फैक्ट इन इशू. ये सब है हमारे फैक्टम प्रोबेंडा. और ये सारे फैक्ट्स हमें कहाँ से मिलते हैं? सब्सटैंटिव लॉ से मिलते हैं. जैसे इस एग्जांपल में ये फैक्ट हमें कहाँ से मिलता है? दैट ए हैड इंटेंशन टू किल बी, दैट ए किल्ड बी. ये सारे हमें आपका सेक्शन 299 एंड सेक्शन 300 ऑफ इंडियन पीनल कोड जो है. एंड इफ ए वांट्स टू डिनाई हिज लायबिलिटी, then A will prove A killed B, but in defense, private defense. But in private defense. So now this is his defense. What was his state of mind? It was not that he intended to kill B. A did not intended to kill B, but he killed B in private defense. He killed B in private defense. So what is a fact in issue? A fact in issue is the actus reus plus the mens rea. I hope everybody is clear on fact in issue. And now we go to the relevant fact. Relevant fact. Now relevant facts are given from section 6 to 55 of your Indian Evidence Act. Now what is the relevant fact? रेलेवेंट फैक्ट्स को हम एविडेंशियरी फैक्ट्स भी कहते हैं. हम इनको फैक्टम प्रोबेंशिया भी कहते हैं. और वी ऑल्सो कॉल देम एज सेकेंडरी फैक्ट्स. सो व्हाट आर रेलेवेंट फैक्ट्स? दे आर द एविडेंशियरी फैक्ट्स. एविडेंशियरी फैक्ट्स मतलब इसी से आप समझ जाइए कि जो फैक्ट्स प्रूव करते हैं किसको? मेन फैक्ट्स को, फैक्ट इन इशू को, उनको हम रेलेवेंट फैक्ट्स कहते हैं. सो बेसिकली रेलेवेंट फैक्ट्स आर नॉट द मेन फैक्ट्स बट दे हेल्प द प्रूविंग ऑफ द मेन फैक्ट्स. दे आर एविडेंशियरी फैक्ट्स. दे आर फैक्टम प्रोबेंशियम. इनको हम कहते हैं सर्कमस्टांशियल एविडेंसेस. इनको हम कहते हैं सेकेंडरी फैक्ट्स. So they are not the main facts, they are not the fact in issue, they will not determine the rights and liabilities of the parties, but together with other similar facts like relevant facts, they will have a logical connection with the main facts. They are logically connected with the main facts. So उनको हम evidentiary facts कहते हैं. Like for example, I continue with the same example which I gave you, that A killed B. A killed B. Now I'm taking this example. Okay. Now इसमें जो अब यहाँ पे आपने मर्डर प्रूव करना है ना, किसको मर्डर प्रूव करना है? बी को प्रूव करना है. ठीक है? All right. So now state is going to file a suit against A. Now when we start the prosecution against A, in that case we will have to prove murder, and in order to prove murder we will have to actually prove that A killed B. A killed B. That how did he kill B? He killed B. A killed B with intention. And ये आपकी होगी मेन फैक्ट्स. अगर आप प्रूव कर लेते हो कि ए ने बी का मर्डर किया, कहां से मर्डर किया, कौन से इंग्रेडिएंट्स फुलफिल होंगे? सेक्शन 299 आईपीसी और 300 IPC. 299 talks about culpable homicide and 300 talks about murder. तो वहां जो ingredients दिए गए हैं, अगर आप वो prove कर लेते हैं, तो yes, A will be charged with either culpable homicide or he will be charged with murder. And that he had the mens rea. So ये आपके हो गए आपके main facts. अब इन main facts को prove करने के लिए there are certain other facts which are not the main facts. They are not creating any rights and liabilities, but they are logically connected with the main. For example, fingerprints were found of A. For example, there was a dying declaration of B. For example, there was an eyewitness who saw A killing B, or there was a discovery statement. Now, what are all these? So these are not the main facts. ये main facts नहीं है. अगर fingerprints A के मिलेंगे main facts नहीं है. But ये क्या है? Fingerprints of A will go on to prove that yes, A killed B. There was a dying declaration of B that A killed me. There was an eyewitness who gives evidence in the court against A. There was a discovery statement. Now, all these are proving the main facts. और ये सारी चीजें क्या है? ये relevant है. They are all relevant under Section 6 to 55 of your Indian Evidence Act. They are called as relevant facts. So whenever an offense or a wrong, which is a civil wrong, that takes place, there are certain circumstances that exist. Now, these circumstances will go on to prove the main facts. They will go on to prove the wrong. तो ये जो offense है और जो wrong है, ये आपका main fact है. और ये आपका main fact है. इनको हम कहते हैं fact in issue. और जो circumstances इनको prove करते हैं, इनको हम कहते हैं relevant facts. Relevant facts. So, for one fact in issue, we may require one or more than one relevant facts. Relevant fact, relevant fact, relevant fact. ये सारे relevant facts क्या कर रहे हैं? ये prove कर रहे हैं इस fact in issue को. Fact in issue क्या है? Primary fact. Primary fact क्या है? A ने B का खून किया. A और B के बीच में कॉन्ट्रैक्ट था. रेलेवेंट फैक्ट क्या है कि हमें A के फिंगरप्रिंट्स मिले, हमें डाइंग डिक्लेरेशन मिली B की विच वाज अगेंस्ट A, हमें एक डिस्कवरी स्टेटमेंट मिली. तो ये सारी चीजें क्या प्रूव कर रही हैं? दे आर गोइंग टू प्रूव द फैक्ट इन इश्यू. So they are relevant facts and they are given under section 6 to 55 of your Indian Evidence Act. These fact in issue are called issues of fact under CPC, like whether A killed B. Issue order 14 of CPC. और इसी को ही हम जब इंडियन एविडेंस एक्ट में लिखते हैं, हम लिखते हैं A killed B और हम इसको कहते हैं फैक्ट इन इश्यू. Fact in issue. So there is no difference between issues of fact and fact in issue. Only thing is that under CPC हम इसको question form में हम उसको put across करते हैं that whether A killed B. That's the main issue. वो main मुद्दा है, वो major fact है और उसी को ही हम Indian Evidence Act में कहते हैं fact in issue and we say A killed B. A had intention to kill B. Now, this is a fact and issue. A and B entered into a contract. B breached the contract. B was a minor at the time of entering into the contract. ये आपके सारे मेजर फैक्ट्स हैं और इन फैक्ट्स को प्रूव करने के लिए जो भी आप और फैक्ट्स देते हैं कोर्ट में उनको हम कहते हैं रेलेवेंट फैक्ट्स, उनको हम कहते हैं एविडेंशियरी फैक्ट्स, उनको हम कहते हैं फैक्टम प्रोबेंशिया. लाइक A and B entered into a contract. We can prove this fact by the document itself. Now that document itself is a relevant fact. It is a evidentiary fact. A and B entered into a contract, but at the time of entering into the contract, B was a minor. Now the fact of his minority is a relevant fact from section 655. It's not the main fact. It is proving the age of the defendant. That is B. So I hope everybody is very clear on what is a fact and issue, and a relevant fact. If you're interested to dive more into this concept and understand what is legal relevancy, what is logical relevancy, and also practically understand with the help of case laws. Those case laws, we can take landmark and also recent case laws on what is a fact and issue, and relevant fact. Please register for my webinar at just rupees 299, where I will be covering the concept of relevancy more in detail with the help of a case law. And if you're interested to understand the entire Indian Evidence Act with threadbare reading of the Bare Act, then go on to my website and fill in the form, and we will get in touch with you for more details on our batch on Indian Evidence Act. And do not forget to share, like, and subscribe